Hi, and welcome to this episode of the Medicaid Moment. I'm Catherine Jacobs, estate planning and elder law attorney with Warner Norcross and Judd. And in these videos, we talk about long-term care Medicaid, the programs that help pay for long-term care for older and disabled adults. In today's video, we are going to talk about a concept called estate recovery. It is the program that allows the state of Michigan to come back and recover or reclaim or recoup or get paid back funds that they have paid on behalf of someone who has qualified for long-term care Medicaid benefits. And it is called estate recovery because the state of Michigan is only allowed to recover against estate assets. So we're going to talk about what are estate assets, how does this really work, and we're going to put it all together. So we have to talk about first, I think, to understand this, what a probate estate is, and that involves understanding how assets transfer at the death of someone. So there are several different ways that assets might transfer from someone when they pass, and we're going to use our proverbial Bob and Shirley as our example here. So let's say that Bob and Shirley jointly own a home. If Shirley dies, that home is not part of her estate, because as joint owners, it becomes just Bob's asset. He becomes the sole owner. No need for probate. It's not part of Shirley's asset anymore. Her interest is terminated. It's just Bob's asset. The same would be true if they had a joint checking or a joint savings or a joint investment account. If Shirley died, that asset becomes Bob's asset. Another way that assets transfer to individuals when we pass are through beneficiary designations, or what we call transfer on death or TOD accounts. So if we use the example of Bob and Shirley, if Shirley has her own bank account just in her name, but Bob is listed as a beneficiary, or it's a transfer on death to Bob, when Shirley dies, that asset is no longer part of her estate. It transfers at her death to Bob automatically. So Bob could go to the bank with Shirley's death certificate, prove that he is the listed beneficiary on that account, and the bank is going to give him the money. That is the same with life insurance policies, retirement accounts, anything where it's a solely owned asset and there's a beneficiary listed. That asset is no longer the asset of the decedent when they die. It transfers automatically to that listed beneficiary. If we have a trust and that an asset is owned by a trust, when a person dies, their death does not affect that trust ownership. It just might kick the trust into gear to say, okay, now Settler has died and we have to distribute this asset. But if, for example, Shirley had a trust and her home was owned by the trust, at her death, that home would not be part of her estate. It would be part of the trust still, and the trust terms would then control how it's going to distribute to her beneficiaries. So when might we have an asset that is subject to this estate recovery? Well, again, estate recovery is only for assets that are part of a probate estate, which means someone had to enlist the probate court to help get that asset to the intended parties. And so let's use the example of Bob and Shirley jointly owning a home. If Bob and Shirley jointly own a home and Shirley dies, the asset, the home, is going to pass to Bob as the joint owner. If Bob dies a month later and he hasn't done anything to change the ownership of the home and he just owns it by himself, when he dies, that home is now subject to a probate estate in order to transfer. Meaning, let's say, for example, Bob does have a will, and in his will it says, I leave everything to Shirley. If Shirley dies before me, everything to my 3 children, okay? In that scenario, Shirley predeceased him, so the things that are subject to his will are going to transfer to his 3 children. But the children can't just use the will. They couldn't take the will to a realtor or a title company and say, hey, we have this will. It says we get everything. Our dad had a home. We want to sell it. Both the title company and a realtor would say, well, we need someone with authority. We need to know that this will has in fact been validated, if you will, by the court, that there's someone that the court has put in charge. So it means that Bob's children are going to have to look at the will to see who's named in the will to be the personal representative, which is Michigan's version of an executor. So who is named as the executor? Does that executor want to serve in that role? Who then that person could go to the court, ask the court to authorize them, appoint them to be the personal representative, the executor, to administer the estate, which would then allow them to sell the home and then distribute the assets according to the terms of the will. So in the case where Bob solely owned that property with no beneficiary, no joint owner, he had to use, or his family had to use, the probate court in order to get that asset to the right people. Now let's add a layer to that example and say that Shirley dies, Bob now owns the home, Bob gets ill, he needs nursing home care, he goes into a nursing home and he applies for Medicaid benefits. And if you've watched some of our previous videos that talk about how you qualify for Medicaid, you know that a single person can qualify for Medicaid. They're allowed to keep a certain amount of resources. In 2026, it's $9,950 worth of resources, $9,950 worth of resources. They're allowed to keep a car and a home. So let's say Bob did that. He had his assets under $9,950. He had a car and he kept his home. He qualified for Medicaid, and let's say that he received Medicaid benefits for a year before he passed. And when he passed, it was discovered that the home that he had did not have a beneficiary or a joint owner, and now it had to pass through the probate estate in order to transfer. In that instance, the state of Michigan could, under the estate recovery statutes, make a claim against that house to recover the funds that they paid on behalf of Bob for his care under a Medicaid program. So then the state of Michigan would come in, they would assert their claim. Let's say their claim was for $100,000, and the children of Bob went, one of them became the personal representative, they sold the home. The proceeds from the sale of that home are going to have to first satisfy that $100,000 claim that the state of Michigan had. So any asset that passes through probate after the death of someone who has been on a Medicaid benefit is subject to the state being able to come in and recoup their funds that they've paid out on behalf. So the burning question is, well, how do we avoid this estate recovery? Well, anytime that someone is applying for Medicaid, it should be the application should be evaluated to see what assets they're retaining to make sure that at the death of that individual, those assets are going to transfer in a way to avoid probate. For a home, that could be using something called a ladybird deed. For bank accounts, it could be just having those beneficiary designations or transfer on death designations. So it's important to do that both when you're applying for Medicaid, and it's a good idea to do that in advance. Most people want to avoid probate regardless if there's an estate recovery. And so in avoiding that probate process, in addition to having your estate planning documents updated, you should make sure that your assets align accordingly and are going to transfer seamlessly without the need of the probate court. I hope that this has been a helpful episode for you. Certainly, we are here to help at Warner Norcross and Judd for all of your Medicaid questions and needs. Have a great rest of your day.